we will be talking about the role played by these countries in international tax planning. As for active companies, of course, when our clients are asking us, always say that substance and presence related requirements are the key requirements. An important point here is that since February the 1st, 2020, there is a register of beneficial owner. Today we are going to talk about tax structuring and asset protection for HNWI based upon the examples of Switzerland and Liechtenstein. In this particular case, everything pertaining to Switzerland and Liechtenstein will be presented here in a general fashion. You will be informed about what it is that the clients are mindful of when they think about these jurisdictions. This is just a brief information, introductory information about myself. As I said during the introduction, I work for the for an entity including lawyers from the United States, from Western Europe, from CIS, and we interact and cooperate with clients from Russian CIS. More than 15 years of I have more than 15 years of experience in Russian business. I've been advising German-speaking firms in Russia on CIS questions and HNWI from Russia and CIS. I was also into solving different issues of transboundary structuring. My contact info is found here on the slide. We move on. As for the content, we will be talking about the role played by these countries in international tax planning. We'll touch upon the fact that currently the clients are asking about active companies, their different legal forms, passive companies with their legal forms. We will touch upon CRS standard in case of Liechtenstein, Russia, and that is how and in which destinations they would have to make their investments, etc. Here, the major point here is as follows. When talking about active companies, the clients are often inquisitive about them. As you might know, active companies have certain advantages and they allow clients to carry out active active types of to conduct active types of businesses. And when our clients are asking us how they could structure their business as an active trading company or as an active holding company with various use of their investments, the major legal form of a legal entity is the joint stock company, because the share capital related legislation in both of these countries is very well developed. So you can find investors in both countries that clearly understand that yes, they will initially invest 5 times more than what they would have invested in case with GmbH. This is a very well regulated mechanism with already existing court practice. Switzerland is one of the best jurisdictions in this area in the world, and you can make your choice with regards to various low tax cantons. And many of the clients oftentimes are attracted by the convenience of business operations in Switzerland. So it's quite understandable that such cantons as Basel, Shahbaz, they have always been very attractive to the neighboring countries. People from these cantons would come to Switzerland, and of course, companies and entities, legal entities in these cantons would be much more competitive, given the fact that it would be hardly possible to visit your one's workplace there on a daily basis. There are different advantages that different other advantages that Switzerland has. As for Liechtenstein, it is very preferential in terms of business opportunities, in terms of tax advantages. It would suffice to say that Liechtenstein is one market with Switzerland, CHF, in terms of CHF and custom union, etc. Liechtenstein is a member of the European Economic Space, the European Economic Zone. It has the same rights as members of EU, but if we consider this issue, the EU members are always indicated as full-fledged EU members, and Norway, Iceland, and Liechtenstein also wield all the major rights of which are equivalent to those of EU members. Sometimes Swiss companies choose Liechtenstein to do business as opposed to any of the EU member states. Also, the Liechtenstein legislation is very well developed. Given the country is very low, it is broadly using case law of Switzerland and Austria. You can clearly see that when reading through different court decisions. The Swiss courts and Austrian courts case law is broadly applicable in Liechtenstein, which is another advantage. From the standpoint of tax legislation, the tax rates are very low. The profit tax here is 12.5%, VAT 7.7%. Same with CH. Next slide, please. As for active companies, of course, when our clients are asking us, we always say that substance and presence related requirements are the key requirements, and they should be necessarily taken into account because both the Swiss and Liechtenstein tax legislation since 2018 have started to consider very closely the Swiss and Liechtenstein Well, since 2018, the Swiss and Liechtenstein tax authorities inspect the place of decision making by management, and if Swiss managers don't come to Liechtenstein and only make their decisions from Switzerland, there are high this could be very well become a matter of to be inspected by the tax authorities. So the local director related legislation has to be implemented here. Also, there's an additional requirement in Liechtenstein here requiring personal presence, supporting documents, and confirmation of bank transactions. Also, you need to prove your active economic activity in Liechtenstein. When you set up your legal entity, you need to take into account a number of requirements, including assets, functions, and risks reporting. You need to take into account the fact that the automatic tax exchange, tax information exchange system has already been implemented between um, Switzerland and Russia. The Russian tax authorities are very closely scrutinize the types of activities that companies have in these jurisdictions. So you need to be prepared for that. The same is done by the Swiss tax authorities with regards to the active companies' business in Russia. Well, according to the Criminal Act, companies without physical substance will be seen as a measure to save tax and hence potential classified as tax fraud. Next slide, please. Uh, this actually can be accomplished by providing employment agreements, lease agreements, utility bills, and or financial statements showing wages, insurance, or rental expenses. You can appeal against this requirement by using local lawyers to evidence that your company is remaining is conducting its business as an active company. Next slide, please. Uh, Banks, of course, require necessary information from the clients. Banks want to see your active status. Another innovation is that company is classified as active under CRS without sufficient evidence of their status will be seen as an indication for money laundering. Next slide, please. An important point here is that in Liechtenstein, since February the 1st, 2020, there is a register of beneficial owner, which is divided into the addendum 1 and addendum 2 and all the uh, pertaining to active companies and passive companies accordingly. The Annex 1 uh, should be used to indicate information about natural persons or physical persons with direct or indirect shares, and Annex 2 should be filled out with the information pertaining to the following to the natural persons or physical persons as well. Here you can see the changes which have been brought into the beneficial owners registry based upon the European directive. As a Liechtenstein, as a member of the European Economic Space, should fulfill Directive Number 4, and it is implemented currently. The Directive Number 5 is encompassing its prerequisite. It will be enacted from April 1st, 2021, and it will bring about a lot of changes. As you might have seen, you might have come across the publication of information from Luxembourg, where a big number of beneficial owners of Luxembourg companies have been identified as they were connected with many many governmental bodies from different countries, including the Russian Federation. This information is going to be unfolded, disclosed based upon AMLD, the Directive Number 5. Here you can see the number of people that will be able to get information from these registers. Also, various structures or foundations registered in Liechtenstein that can directly or indirectly participate in legal entities or structures outside of EAEU, they will also become subject of this directive if they're located in Dubai or some other countries. Information about them will also be provided to tax authorities, and you should take that into account. In this regard, of course, clients have certain questions as to the structuring of their assets and different ways of protecting their assets. For example, the residency a resident from the Russian Federation would have irrevocable discretionary structures with unlimited options. And we should take into account one important court case that we actually, from the standpoint of Liechtenstein legislation, the establishment of such irrevocable discretionary foundation or structure when there are some unlimited number of actors and beneficiaries, this amounts to a situation where this foundation can be actually deemed as obsolete. So when it comes to the issues of structuring, please make sure you can protect your assets when structuring. when structuring them. In this connection, we have a situation whereby clients are asking, they say we have different types of assets or quite large positions in Russian banks or several businesses in the Russian Federation, and some of the some of the positions that we have in the Russian Federation, we would like to invest some of these positions in Europe in various types of products. And in this connection, they ask about possible ways of structuring this kind of activity and whether or not there are certain optimal parameters that could be used. So that's why we established a private label investment fund, which is completely or fully regulated in Liechtenstein. It is into asset management and investment and bankable assets. And also you can see the tax. There are certain tax implications, of course, but you get an opportunity to make investments, to invest your assets from the Russian Federation or other markets and invest them in the European market, in and invest them in on the European market in some products. There is a similar situation when a client came up with a foundation which is not to be which is not which is actually a reinvestment fund, because revenues of the foundation were all the revenues of the fund would be reinvested, and this is to be taken into account as well, because from the practical standpoint, investors would like to see some sort of stability, some sort of market stability. And when discussing this with our clients, we see that they want to see a clearly regulated structure of the market, they want to see the investor protection directives, like like the alternative investment fund directives and alternative usage fund directives that are active in Europe, capable of protecting investors on the legislative level. That allows the clients to use the assets of foreign investors as well. And you need to consider all the options and select those that are of preference for you. Now I have depleted all of my slides of my presentation, and now I can start answer questions. Well, here's the situation in this area. In Liechtenstein, if you Google this information, if you use Google, you can find this information on your own as well. Please do not be dismayed by these by 3, 5, or more years that you can come across here. The trustee that receives this property, the assets, they should know everything about the background of of the asset. The fund should know everything about the assets, um, the overall period of time, the overall period of time for the fund to take into account is currently 10 years. That is, the fund should know everything about the assets in the past, everything that has taken place with the assets in the past 10 years. In real practice, you will frequently encounter a situation when local trustees will require a legal opinion of independent providers from you to 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 tell you whether or not they can approve the withdrawal of the assets or investments of the assets or not. The funds themselves, they understand this very well. The longest period of time is 30 years, whereas the shortened period of time is 10 years. That is, the fund should know everything about the assets background in the past 10 years. Back then it was irrevocable fund, but it could be deemed obsolete to be deleted from the register. If you have any other questions to ask, you're welcome to ask them. Anastasia is asking. She says, "I'd like to know your opinion about the participation of settler in the management of assets in the context of acknowledging the foundation effective with all the implications." You know that this situation is frequently occurring with our taking place with our clients. They say that they would like to manage the foundation as settlers, but we actually we are not recommending this, and we say that you always have the independent protectors. You can bring them into your structure to protect your interests, but when it comes to the management, to the foundation management, we do not recommend this. We do not recommend this to be done because it actually creates certain risks from the standpoint of the virtual management location, when the Russian tax authorities can just start asking if the settler has this kind of powers. Perhaps the fund could be managed from Russia, and for that reason, we always say that it's better not to do it this way.
and move there with your family to operate the company. Да, смотрите, в целом это возможно.
Yes, by and large, this is possible both in Liechtenstein and Switzerland. My example is as follows. We set up a company in Liechtenstein. The lawyer's firm was established in 2017, allowing for my family to move from Moscow to Liechtenstein. And the government of Liechtenstein made the decision on the relocation. They usually make decisions on the countries of on citizens on the relocation of of third countries citizens, uh, including Canada and some other countries. Back when I was when we were relocating, there was a requirement to know the German language. Right now, this requirement is obsolete. Also, you can the same is true about Switzerland. You can relocate your family to do your business there. Switzerland, I would say right away that Zurich has very high profile requirements for such legal entities and companies. If you want to set up a company in Zurich, you would be required to establish a certain number of jobs. Uh, if you create this number of jobs and report on them, you will have fulfilled the requirement. And also the there are certain we have had examples whereby we have had cases when people would come from Russia to German speaking cantons and they still reside there without any problems. And these cantons did not require for them to create any number of jobs. And there is a certain competition between cantons in this particular area. They compete in terms of they compete for projects and for the number of for in the area of job creation. These are probably all the questions that you have asked. You can ask questions to me, to Jamie, to Urs. We would stand ready to answer them. You will find the contact info in my presentation, including my mobile phone number, my email. We can always get on the phone to discuss your situation with you, and I can tell you how we see the process. And from the practical standpoint, I can tell you right away that from the standpoint of active companies, last night we met with a Russian founder of an active company from Moscow. He established that company in November 2020 in Switzerland. We assisted the process of the company's establishment. We have done all of the we established the company in a remote way. The the embassy and the immigration office secretariat received the information about the business, the established company, and a week ago, the person has crossed over the border and entered the country without any impediments. So I'd like to say that whether you want to establish an active company with your own presence in with, follow, followed by a relocation to do the business, or do you want to do it otherwise, we can discuss all of that with you and we can share our know-how with you.